Right, appearances for the people versus Frank Mishaw Jr.
Good afternoon, Your Honor. Mohammed on behalf of the people, P86771.
Nice. You have work, so
Yeah,
you're on the side here.
Are you representing yourself?
The judge needs to address yourself. Is that a problem, sir?
Yeah, you're a defendant. Sit at the defendant's chair.
I'm not defending. Sorry.
Judge, if I may try to help explain.
Try.
I'll try. Mr. Michaud is a sovereign citizen, and
No, I object. I'm not a sovereign citizen.
All right, sir, don't speak.
I maybe am not phrasing that correctly.
Don't speak until I ask you to speak.
But there is a difference between Frank Michaud, or I think it is Mr. Michaud's assertion that there is a difference between the natural person, Mr. Frank Michaud, and the sort of legal entity.
I don't recognize that.
And that's what I've prepared Mr. Michaud for that.
Sir, you're a defendant in my courtroom. Either I issue a bench warrant because you haven't appeared, or you come up here and sit in the chair and we proceed.
All right, so you're threatening me to.
Absolutely, I'm threatening you. Either you're here today or you're not. If you're not here today, a bench warrant will issue. If you're here today, I need you in the chair so we can proceed with the proceeding that's scheduled, which is a...
Welcome back, everyone. Today's courtroom drama is one for the ages. We've got Frank Mishaw Jr., a self-proclaimed sovereign citizen, squaring off against Judge Oakley, a judge known for his no-nonsense approach. If you've seen sovereign citizens before, you know they thrive on pseudo-legal jargon and endless objections. But Oakley, he's not here to play games. This clash is about to escalate from jurisdictional debates to outright contempt, and trust me, you'll want to stick around until the end. Because when delusion meets reality in Judge Oakley's courtroom, reality always wins.
The courts receive objections all the time, overrule objections that are preserved on the record. If he has...
He can appeal me. I'll let you build whatever record you want to build, Mr. Mishaw.
Are we on the record?
Yes.
Are you on your oath to the Constitution?
Hold on, what? Are you picking him up? That's one of the reasons I want you up here, is through the microphone here.
I'll speak loud.
Are you picking him up? Yes. Go ahead.
Are you honoring your oath to the Constitution today?
Pardon me?
Are you honoring your oath to the Constitution? You have an oath to the
I didn't swear an oath to the Constitution.
You haven't.
I took an oath that said I would follow the Constitution.
To not uphold the Constitution?
Yes, follow the Constitution.
So you are upholding an oath to the Constitution?
Yes.
Thank you. I accept your oath. Thank you. Okay. Now I have.
Sir, get your ass in the chair or leave and I'll issue a bench warrant. You're not running the courtroom. I am. If you want to have an exam today, get your ass in the chair. That's the way it works.
I reserve all my rights.
I would have nothing less. Now, are you representing yourself today?
I'm presenting myself.
That's not what I asked you. Are you representing yourself, or is this gentleman going to be your lawyer for today's proceeding?
I will be presenting myself today.
May
All right, so that's a no. You don't want him to represent you?
No, for the record, he's not my lawyer. I don't have an attorney. I present myself.
Okay.
Judge, what I have recommended to Mr. Michaud is that he has a jurisdictional argument that he wants to make, and that, you know, pending Your Honor's ruling on that jurisdictional issue, I have prepared for to conduct a preliminary exam.
Okay.
And could be, you know, available if he wanted to ask me to do that at the correct time.
So you want to represent yourself for that jurisdictional argument, and if I rule against you, then perhaps you want him to represent you? Is that what I'm hearing?
No, that's not what you're hearing.
All right, so you don't want him at all under any circumstance?
No, I don't need an attorney for the record.
Here's the first power move. Judge Oakley makes it crystal clear. Sit in the defendant's chair or face a bench warrant. No wiggle room, no theatrics. Sovereign citizens often try to stall proceedings by refusing to acknowledge the court's authority, but Oakley shuts that down immediately. This sets the tone. He's not going to let Frank hijack the courtroom. Audience question: do you think more judges should take this hardline approach right from the start?
So, with that being said...
Well, hold on. You can stick around if you want to, but I'm not going to obligate you to stay.
I understand, Judge. I'm definitely going to stay.
That's fine. All right.
So, today...
You have a jurisdictional argument you want to make?
Well, I served notice.
Sir,
on
it's a yes or no. Do you have a jurisdictional argument you'd like to make today?
I have a.
Yes or
multiple-
no?
Why are you forcing me to say answer?
Because I'm running the courtroom and it's the way I want to do it. Do you have a jurisdictional argument you'd like to make today?
I do, yes.
Then make it. What's your
Okay,
jurisdictional
so
argument?
I'm presenting myself. So I need to know, Article 6 of the Constitution grants me the right to know what jurisdiction is this court operating up under?
State of Michigan.
No, what jurisdiction?
State of Michigan.
Okay, what jurisdiction is the state of
District
Michigan?
courts are legislative courts. That means they're created by statute. The state of Michigan gives me my jurisdiction.
So, okay, is that?
I work
criminal
under the authority
or
of the state of Michigan.
What is it, under what jurisdiction? There's two different jurisdictions under the Constitution. You have admiralty and common law, so I'll need to know.
This is
in
not
order-
admiralty,
What is
and
it?
it's not common law.
Which
It's
one?
statutory.
Okay, so it's statutory, that is what, civil?
No,
So what is it? For the
My
record, I need to
jurisdiction
have
is
that
both
on-
civil-
I can't defend myself unless I have it on.
Frank insists he doesn't need an attorney, claiming he'll present himself. This is a classic sovereign citizen tactic, rejecting legal counsel because they believe the system doesn't apply to them. But here's the irony. By refusing a lawyer, he's stripping himself of the very defense that could protect him. Judge Oakley knows this, and you can hear the disbelief in his tone. It's like watching someone walk into a storm without an umbrella, convinced they won't get wet.
my jurisdiction is both civil and criminal as provided by the statutes of the state of Michigan.
Okay, so today, under which one is?
This is a criminal case.
Okay, right, so is that common law or admiralty?
It's statute. It's neither common law or admiralty.
It's one or the other. It don't say statute.
All right, then you can appeal my
Constitution.
ruling. My ruling is it's neither admiralty or common law.
So this is you say it's criminal for the record.
Yes,
Okay, and if it's criminal, in order for a crime to exist, there must be an injured party for the record, right?
there must be what?
An injured party.
Yeah, it's the
A
people of the
corpus
state of
electi.
Michigan.
All right, so if the people of the state of Michigan, right? Where's the sworn statement?
Where's what?
A sworn statement. I have a right to see a sworn statement saying I injured someone.
There's a complaint in the file.
Sworn complaint, signed, all,
You want to see it?
affidavit, sworn affidavit.
No, it's not. I don't think it's an affidavit.
Well, okay, so
You said you wanted a sworn complaint.
from an injured party, who have I injured for the record?
The state of Michigan
How can I
are
injure the
bringing the
state?
charges.
How can I injure the
Sir,
state?
sit down. Sit
I'm saying,
down.
I'm not.
Sit down, or I will hold you in contempt.
Another threat, wow.
And here's the breaking point. Frank interrupts again, and Oakley slaps him with a $100 contempt fine. This is the judge drawing a line in the sand. Speak out of turn, pay the price. Sovereign citizens thrive on chaos, but Oakley is methodically stripping away their control. The fine isn't about money, it's about authority. Oakley is reminding everyone in that room who runs the courtroom. Do you think Frank will finally back down? Spoiler, not a chance.
Proceed. Do the people have a witness they'd like to call in the exam?
Yes, Judge, the people are prepared to move forward. Just as a quick preliminary matter, we'd request a mutual order of sequestration with an exception for the
So-
OIC.
So again,
I'm not asking you to talk. Ma'am, are you a possible witness in this case? Okay, all right, and would you mind putting your name on the record, please? Counsel, I want to look at the lady. Would you mind putting your name on the record?
She's a witness. She is a witness.
Sir, you speak again when I haven't asked you to, and you're in contempt, and we'll deal with that first. The reason I need your name is because if you appear somewhere down the road and want to testify, we have to know that today you were in the courtroom. And I can't do that by taking a picture of you, so I'm asking you to state your name. Sir, you are in contempt of court. That's a $100 fine. Speak again when it's not your turn, and I'll continue to up the ante. Clear? You can speak now. I've asked you a
I
question.
object.
I don't give a shit if you object. Is it clear what I said? I'm waiting for an answer.
I said I object. What I'm supposed to say?
I want to know if you understand you've just been fined $100 for contempt.
I don't understand.
Okay, well, you still.
This section is pure gold. Frank insists he never waived his probable cause hearing, confusing it with a preliminary exam. Oakley patiently explains the difference. A probable cause conference is basically a pretrial meeting. while the preliminary exam is where probable cause is actually tested. But Frank refuses to listen. This is the sovereign citizen paradox. They demand answers but reject them when given. Oakley's frustration is palpable, and honestly, it's hard not to sympathize.
Witness.
Your Honor, the people called Officer Steffen. Oh, I'm sorry. One last quick preliminary matter. Pursuant to 76611D, we'd like to introduce a certified registered of action in regard to this individual being a previously convicted felon.
I object.
Hold on, have you showed that to him?
I object. I object.
What's your objection, Mr. Michaud?
My objection is that I am here under the guise of a
Bless you.
probable cause conference. And I don't know how we're here at a preliminary exam when I did not waive any right to waive a probable cause.
This is a preliminary exam.
This is, okay, so right here it
This
says,
is the probable cause hearing.
it says,
All right,
it
stop,
says-
stop. Right now, the question on the table is, you've objected to admittance of that document. I want to know what your legal objection is.
I'm also objecting.
What is your legal objection?
To not waiving my probable cause hearing.
Denied. That's admitted.
Under what grounds am I denied not?
Because
have
you
my
didn't
due
give me a
process?
valid objection.
I object.
You can't just object. You got to explain with the valid
I
objection to the
object
evidence.
that we are having a preliminary exam when I haven't had a probable cause hearing that I did not.
They're the same thing,
It's
Mr.
it's
Michaud.
still, on this. it
Mr.
doesn't-
Michaud,
it
they're the
doesn't-
same thing.
But it's still, I have a right to a probable cause. Am I right or wrong?
Sure, try.
Am I right? Do I have a right to a probable cause?
That's what today is scheduled for.
But today it says preliminary exam. Right here it says probable cause conference, and today is a different date that says a preliminary.
Have you
exam.
ever had a grilled
If it
cheese?
was different,
Have you ever
if-
had a grilled cheese?
if it was different, why would it have two separate?
Have you ever had a
columns?
grilled cheese?
I object to any of that. Why would it have two separate columns?
Take him out.
Why would it have two separate columns?
I'm not playing this game with him today. If you think you can get him to shut up long enough so we can have our hearing, we'll do it. But I'm not gonna let him try to run my courtroom.
Okay, I'll just be very brief in my one attempt here. I would like to try to explain what I understand Mr. Michaud's objection to be, and what I have also represented to him regarding that objection. Mr. Michaud, I think the court record will reflect, had a probable cause conference first on November 29th, and then again on December 20th. I have disclosed, I think I've been very transparent with Mr. Michaud that probable cause conference is a bit of a misleading name, because probable cause conference under the court rules does not require that probable cause be established.
Right.
At the second probable cause conference, Mr. Michaud was caring for a sick relative, so he wasn't able to attend that probable cause conference scheduled December 20th.
Which didn't hurt him at all.
Right. I represented him on that day, and I asked the court to waive his appearance so that he could remain with his family.
Which we
I
did.
understood to be his wishes. I may now understand differently that I misrepresented him in some way, but my goal was just to be able to conduct a probable cause conference where we were going to find out if there was any offer, whether discovery.
You don't have to tell me what they are. I know what they
I
are.
know, but I'm just trying to explain.
And I'm trying to explain it to him too, but I'm not gonna talk over him.
Right.
And I'm not gonna play that crap today.
Right.
So if you want me to explain what's scheduled today versus what was scheduled last time, I'm happy to do that, but you gotta be quiet while I'm talking. Clear?
Oh, dude, I hear you.
All right. The last court date that we call a probable cause conference is like a pretrial on a misdemeanor. It gives the parties a chance to discuss the case and see if there's any resolutions prior to the next step. Next step being preliminary exam. At the preliminary exam, the people have to prove to me that there's probable cause to believe that there was a crime and there's reason to believe you were involved. That's what's scheduled today. That is a probable cause hearing. Probable cause conference is just a name that we all came up with instead of saying it's a pretrial for a felon. Do you have any questions based on that?
If it's a hearing. or
You
a conference,
didn't
right,
waive it.
so
There's nothing to
do
hold.
I have a right to have a probable cause conference?
No,
What?
you can do that right now. Do you want to make a deal with the people?
I want to be able to prepare myself for the probable cause conference.
There-
And in order
There's
to
no
prepare,
preparing for a probable cause
It's-
conference.
it's
It's a
pre-
conversation.
It still take preparation.
You want a PCC? Go out in the hallway, have a PCC with the unrepresented defendant.
Judge, just for the record, there will be no offer at this stage.
There's your PCC. Now, do you want to plead guilty? Do you want to have an exam? And at the exam, he's got to prove to me those two things I just said. Probable cause to believe a crime was committed on this date and reason to believe that you were involved. Do you want to have that hearing so he has to prove his case? Or do you want to waive? That's the other option. You can waive the preliminary exam and we'll take the case directly to circuit court level 2 weeks down the road for an arraignment on information, which I would describe as another pretrial on a felony, where you and the prosecutor can discuss the case, see if there are any offers. That's another option. Would you agree with that assessment, Mr. Sullivan?
I would agree, and I would also just add that Mr. Michaud has made his arguments today, he ruled on his arguments, and that he preserves his right to.
He can appeal them.
As you've already said, at circuit court. And so if he wants to sort of move forward on that defense alone, that, you know, the waiver does not preclude him from
Not at all.
arguing jurisdiction at the circuit court level. But likewise, if he holds a preliminary exam today, holds the people to that burden, he also maintains the right to, you know, continue his objections to jurisdiction, to appeal the court's orders regarding jurisdiction at that next level, at the circuit court level, assuming that the people are able to prove probable cause today.
Now, do you want to have an exam today?
Well, I wanted to address some, I served the court some notices.
I haven't read any of that because you were